say it in the reverse, Your Honor.
Great deal of respect for all of the families and various interests that exist in this courtroom and otherwise. As in many cases, there can be evidence that elicits an emotional response. If you feel like you are one of those people, just to make sure, I want to ask that you go ahead and try to take a step out if you think that evidence is going to be impactful in some way. And I say that in every case that I try, particularly when there are significant pieces of evidence that may elicit a response. So please don't feel like singling out any particular party or case. But if there's anybody here that feels that way, just please take a moment and step out. You're welcome to come back here.
To say it first affirmatively, I'll remind the court that the court shall have the discretion or be authorized to release a person on bail if the court finds that the person poses no significant danger to person, community, or property. The opposite would be that where the evidence shows that the defendants, as depicted in these photos, have demonstrated a danger to person, the community, and the property, they are not entitled to bond as a matter of right. And the facts of this case as presented in State's Exhibit Number 4, and now with the video and stills that the court has seen, demonstrate that these defendants, Greg and Travis McMichael, are a danger to person, property, and the community. And to add to it, Your Honor, that their views, their worldviews, are significant in terms of their danger to person, community, and property. They also impact whether these defendants are potentially a risk of flight based on concurrent investigations that have been made pertinent, I'll tell the court, by the defense, from the crime scene to present by the defense. This evidence that was just displayed before the court was not manufactured by the state. It was discovered by the state and is consistent with other evidence that's been found through an examination of phone records, social media, and those types of things to show that it has great bearing on this court's decision as to the fourth prong, with risk of obstructing justice, and the first prong, risk of flight. So we have here displayed the law, and I will just remind the court that bears repeating that if you find that these defendants pose a danger to persons, community, or property, and a failure on any single prong, obviously, would require that this court deny bond, as it is discretionary since the defendants have been indicted in a timely fashion. These next photographs are a home here in Satilla Shores that was struck by a stray gunfire. And this goes directly to the prong of danger to person, property, or community, in that you're seeing property damage, community damage, and human damage. There are three subparts then to significant danger to person, community, and property, and the state is showing you now why these defendants fail on that prong on all three of those. A civilian could have needlessly been killed because of the gunfire that Travis McMichael intentionally did in the middle of that street. And but for the grace of God, that round did not strike somebody in the community. It only damaged property. But that is a factor that the court must consider, staying focused not on the trial of the case, but the four factors in this particular case. And in terms of danger to the community, I'll now submit to the court a portion of a phone call where Greg McMichael refers to what happened, the shooting, as a good deed.
I think about y'all every minute. I appreciate it. Yeah, I just all night last night. I can't sleep. I can't, go. I got my mask on and everything. I'm trying to sleep, but I can't. It's just, I wake up every 15 or 20 minutes. It's bothering me.
You've heard the old saying, "No good deed goes unpunished."
Yeah.
Well.
Yeah, that's it. That's a shining example right there.
So when it comes to risk of danger to persons, community, or property, you have Greg McMichael saying that no good deed goes unpunished, referencing the shooting in this particular case. And that certainly is belying of the mental state of this defendant who thinks that what happened was appropriate. The social media presented to the court in State's Exhibit Number 9 demonstrates clearly that defendant Greg McMichael has vigilante views at a minimum. We have presented a status update, and court has seen it, of this defendant was from Identity Dixie, which is a known hate group that's being monitored by the Southern Poverty Law Center. This is instructive for the court not only to danger of person, community, and property, but also risk of committing a new felony, and then risk of flight, I would submit to the court, most importantly, because of what the court's aware of, the ongoing investigation by the Department of Justice. Similarly, staying on the prong of danger to community, you've seen and heard about Facebook posts and things like that by Travis McMichael, where he talks about arming up and dispatching a threat. So, as to prong one, these defendants fail on that prong. They have failed to submit evidence to the court in support of this factor. The state's rebuttal evidence to the contrary shows that they are not good candidates for bond as to prong number 1. Let's talk now about obstruction and intimidation, which will be prong number 4. And the evidence before the court will show that they failed on this prong as well. A court shall be authorized to release a person on bail only if the court finds that the person poses no significant risk of intimidating witnesses or obstructing justice. In this particular case, the state in rebuttal has submitted ample evidence that these defendants have been actively attempting to obstruct justice, and the failure on any one of these prongs, including the one we're discussing now, would be sufficient for the court to deny bond. In support of that, Your Honor, State's 19 body cam video number 1 of defendant Greg McMichael. Within 1 minute, defendant Greg McMichael is identifying himself as former law enforcement in an attempt to influence this investigation, in an attempt to obstruct the police officer's investigation of this particular case. So, Judge, with that, this is within a minute of officers discussing with him.
And so I grabbed my step back. It's an old Glenn County PD issue, by the way.
Within a minute, he's throwing out that his revolver is Glenn County issue. That's a 505 of that exhibit, Your Honor. He's actively inserting to investigators in this case who are on the scene of a homicide that he's former law enforcement, such that that should be a factor and weigh in their approach, and that goes directly to risk of obstructing justice. To continue on and in support of that, from 711 to 720.
Hey, give me just a minute. I was chief investigator for the DA's office for 23 years, so I know what you got to do. I know everything, Yeah, we're just.
The defendant, Greg McMichael in particular, is very quick to insert himself and tell that he has some sort of law enforcement training above the average person, and you've heard the post records and rebuttal of that to show that the contrary is actually true. He was not post-certified for a number of years. To continue on.
Let's go. So I haul that into my bedroom, get my 357 Magnum. It's just Glenn County PD issue, by the way, that I told you years ago.
Poses significant risk of obstructing justice by inserting things that are irrelevant to the case in the hopes that that will impact what these investigators were doing at the time.
Okay. All right.
This is the coroner asking questions of law enforcement.
All right.
Any information?
I do not.
Okay.
Yeah, there was a struggle. He ended up getting shot in the chest, from what I understand, 2 times.
Did you live around here?
Not that I know of.
The victim, he makes frequent trips to the neighborhood, gets caught on video cameras like every third or fourth night breaking into places, and nobody's been able to catch him. And having recognized him from the video I'd seen not too very long, or several days ago, I'm standing out in my front yard when he comes running by I'm not talking about driving, I'm talking about hauling ass past my house. I ran inside to get my son. I said, the guy that we saw the other, or he saw the other night, I said, he's running down the street. So that's when we started trying to find him, trying to catch him. And I left my cell phone, so I couldn't call anybody. Travis had his, but he was busy driving.
Note how quickly the defendant is to insert himself into the investigation of this case, which goes to prong number 4, significant risk of obstructing justice and influencing the investigation. To continue on with this evidence, State's Exhibit number 17 are phone records. And at 2:14 from the crime scene, this defendant calls then DA for the Brunswick Judicial Circuit. And at 14:34 in the phone records, this defendant from the crime scene calls Glenn County Police Department supervisor. We submit this evidence for the purpose of showing that this defendant is a continued risk of obstructing and influencing this investigation.
Objection, Your Honor. There is no evidence of the phone call at 14:34. There's some phone records in evidence, but no witness testified about what that phone number related to. There's a phone call at 14:14 to the district, leaving voicemail to the district attorney, his former employer, but not 14:34 when the county needs to go.
It's in State 17.
It is in State 17 phone records. No testimony about who that phone number relates to.
It's in evidence.
There's a phone call that was made at 14:34.
And a phone record saying one phone call from Greg McMichael's phone to a number.
I understand that.
Hey, you need me to bring it up, Judge. Just before the court, if you open State 17, I believe that you'll see that it's identified which phone call. I'm happy to open it for the court now if you'd like.
I don't think there's no dispute a phone call was made. The way it's characterized by the state is that there was a phone call made to a Glenn County PD supervisor.
It's identified as a call to Tom Junk, yes, who is a Glenn County it's identified in the State 17. If you want me to...
No, I just want to make sure I understand the objection.
Yes.
So I understand what the objection is. There's no reporting, there's no conversation.
There is no
There's a telephone call that is documented.
About who Tom Junk is. And to be clear, Tom Junk is not the sheriff. But no evidence about who Tom Junk is.
State 18 is the voicemail left to then District Attorney, and this goes to prong number 4, risk of influencing and obstructing justice. From the crime scene.
Jackie, this is Greg. Could you call me as soon as you possibly can? My son and I have been involved in a shooting, and I need some advice right away. So please call me as soon as you possibly can. Thanks. Bye.
This evidence shows from day 1 there was an attempt by these defendants to influence and obstruct the investigation of this case. As to all the evidence that was presented from defense's witness regarding Greg McMichael's former employment as Glenn County law enforcement, in rebuttal to that, we have the post record State's Exhibit 20, which you've heard about today. And I want to be clear on this, Your Honor. I am not saying, the state is not saying, that the effect of these phone calls and discussions, voicemails to the DA then, that it had the desired effect. That's not the standard that the court must look at. You must look at whether the defendant had the intention of obstructing and influencing the investigation, and that's the purpose of this evidence, is to show that he wanted to influence and obstruct this. So the standard is pose significant risk of intimidating witnesses or obstructing justice, and that's the evidence that we're presenting before the court now. The post records are also instructed to the court in that on the very first page, you can see that from defendant's perspective, reaching out to his former employer had a benefit to him in the past, in that despite saying that she was embarrassed by defendants' inability to keep his post-certification, when called upon to intervene for his benefit, in the past that worked for him. And that makes what happened in terms of the phone call and the phone records and the voicemail, it makes those things that much more significant. In that State's Exhibit number 20, the letter documented in the post records show that it had the desired effect in the past. Whether it had the desired effect in this case, we'll leave for another day. And there is evidence, if you look at States 20, of that DA intervention that benefited the defendant at some time in the past, which is why, from his perspective, making these phone calls and doing the things that he did, including interjecting his law enforcement background, from the state's perspective, is an obvious attempt to obstruct and influence the investigation. To continue on with this evidence, Your Honor, State 17 phone records also reveal that after the shooting and before defendant's arrest, he was actively communicating with co-indictee Mr. Bryan. And I know the court will recall that evidence as presented, State 17, from the prior bond hearing involving Mr. Bryan as well. So on multiple successive dates, this defendant was communicating with a co-defendant, which goes to influencing and obstructing. And as documented in State's Exhibit number 4, this defendant actually, Greg McMichael, referred to Mr. Bryan as an ally, which goes to this prong of intimidating witnesses and obstruction of justice. The next topic, unless the court needs me to pause, is to talk about Lindsay and social media. This becomes significant because of some of the cross-examination of Lee McMichael regarding jail calls that are captured regarding Greg McMichael actively attempting to obstruct the investigation of this case. So State's Exhibit number 12, May 16th, he's asking Lee McMichael to have Lindsay get rid of evidence in terms of social media.
Good.
You were telling me about Lindsay.
Huh?
You were telling me about Lindsay.
Yeah.
Is she there with you now?
Yeah.
She has got to stop.
She will.
You can get rid of that stuff.
Yeah.
Make it disappear. Make it go away. Because
Yeah.
accessing it. If not, it's liable to really screw us up.
Well, what stuff are you talking about?
I mean, her
Really?
post on Facebook. And
She's not posting anymore.
well, it doesn't matter. They'll go back and look at the shit she has posted. Do you remember all the crap we saw on her phone when we had it?
Yeah. Yeah. That's too late, Greg. I already got that.
But no, they don't. They don't already have all of it. There's people trying to get it all the time, and there's still stuff out there that they haven't gotten. She's got to close out those accounts and get the fuck off of them.
She did close out those accounts.
No, she didn't. She shut them down, but she didn't close them out. She didn't completely eliminate them. She just put them on hold.
No.
All right, well, if that's the case, then that's the case.
This is evidence of this defendant actively, while in custody, trying to obstruct the investigation of this case and influence witnesses by calling Lee McMichael and asking her to have his daughter delete things from social media that were the source of investigation in this particular case. To continue on, Your Honor. States 12-5-16, that's May the 16th, defendant talks about his own accounts and about deleting them in an attempt to obstruct the investigation of these crimes.
Well, I'm writing down what I can, as best I can remember, what are possibilities as far as
Yeah.
what codes go to get in there. Because
Okay.
I'm gonna have them on this.
Because you're still wide open.
That's what I hear.
Yeah. You never did.
You never did close it. You just changed the name and never did close it down.
That's what Lindsay did with hers too, by the way.
Yeah, me too, I think.
But I'm trying, I can't remember my access codes or my passwords. I'm trying. I'm writing down everything I can think of. I'm going to have a list.
Right, Lindsay's going to update her phone, and that one's going to learn.
What's that?
Give her this one. We're going to update her phone.
Yeah.
Probably. But you can't close down a page. I think they got everything they need. No. It'll change your phone number anyway.
Well, I hope they don't have all the shit that we saw on our phone that time.
Well, they do. They have everything on it. Yeah.
Again, Your Honor, staying focused on our 4 factors as we must during this bond hearing, this evidence decisively shows that defendant Greg McMichael poses an active and significant risk of obstructing justice in that he is working with family members to delete and get rid of evidence of significance after his arrest. States 12, May 17th, defendant refers to having his account killed.
Was y'all able to get my account killed?
He took both phones with him.
Good.
Because I couldn't get into it. He said, don't worry about it. Let me take it off.
This evidence goes directly to prong number 4 of 1716-1 in ILA, posing a significant risk of intimidating witnesses and obstructing justice. In addition to that, Judge, if we were to continue on with States 12, and I'm not going to play multiple more clips, I don't think that's the best use of our time. He talks about a particular witness and tells Lee, when he answers the phone, you tell him flat out not to say anything. That's influencing a witness, and that's recorded in a jail call as well. So in terms of influence and obstruction, I'd ask the court to look closely at the defense affidavits that were submitted here of fact witnesses, and note all the times that Travis McMichael and Greg McMichael are referred to as having spoken to them prior to the issuance of those affidavits. That goes directly to obstruction and influencing witnesses, in that these defendants were on a campaign. It was a campaign to influence witnesses to their benefit in this particular case. Continuing on with this prong, I want to talk briefly about jail mail and the coded letter and the handbook. So that is included in States 13 and 14. States 13. Some things to note about this letter, Your Honor. From Greg McMichael, inmate ID, to Zachary Langford, a witness that you heard from yesterday, Your Honor. And here is the code itself. That's available to the court. I know you've seen it on the thumb drive. To a witness that the defense called in support of their bond here. And then for the risk of intimidating witnesses and obstructing justice, Your Honor, and also for a factor that I'd ask the court to consider about whether Greg McMichael in particular is capable of following the instructions of the court were you to grant him bond. Let us now look at the inmate handbook, which has the rules for mail. Inspected and confiscated if written in code. The purpose of putting this in, it goes without saying, Your Honor, is to show two things. Significant risk of intimidating witnesses and obstructing justice, as well as a factor that I think the court should consider whether, as a good candidate for bond, this defendant would be willing to follow the instructions and rules of the court if bond conditions were imposed on him, despite the fact that he is actively defying the rules of the Glenn County Sheriff's Office. Influencing and obstructing. and I don't think I need to belabor the point of the racist communications that the court heard about yesterday. That actually goes to a number of things. It could go to significant risk of committing a new crime. It also goes to risk of flight now that we're talking about a concurrent Department of Justice investigation as well. Now, Greg McMichael is not the only person who's talking about actively having people delete and get rid of evidence. Here's a phone call from Travis McMichael to Lee McMichael involving his sister and having her phone turned off to help evade our investigation in the case.
Right.
Piss me off, you know.
Yep. Yep. I'm trying to send her away, but nobody would take her.
Nobody's done it. I don't blame them. Just turn her phone off. She's on your plate. Give her that other phone that I have for calls only, okay?
Yep.
Remind the court that the failure on any one prong is sufficient for you to deny bond. Here we have now Travis McMichael actively obstructing the investigation of this case. I now want to talk briefly about flight risks, Your Honor, which is a factor that the court must consider. It's the first prong. The court shall be authorized to release a person only if the court finds that the person poses no significant risk of flight, which I believe is a factor for the court to consider here. As shown to the court, these defendants were initially charged with felony murder, aggravated assault, and party to the crime thereof. Our aggravation notice puts them on notice that life without the possibility of parole is an option in this particular case if convicted. Their social media, evidence of racism, and State's Exhibit Number 6, the public DOJ, Department of Justice, announcement of this concurrent investigation certainly should give the court pause as to this particular prong about whether these defendants pose a good candidate, either of them, good candidates for bond. We submit to the court that because of this evidence that we've submitted to the court, they are not. And they are a risk of flight because of the possibility, I even say maybe probability, that there may be additional charges that are forthcoming for them.
That is so objectionable. We talked about this yesterday. I think it's all right. It's the state's position. I'll take this one.
The SPLC document, the business record, is State's Exhibit Number 7, and that's for the court's review as well in support of this flight risk. Consistent with that, Your Honor, you've heard about racist social media, racist messaging. There's a racist text message about having no, I won't say the word, ends around, and that's available to the court as well. This all goes to the danger. It also goes to risk of flight based on what's been shared with the court. There's some social media that was recovered by the state as part of this investigation. First, pertaining to Greg McMichael, a video clip that was recovered from his social media, admittedly sent to him, but I'll ask the court to note in context this racist song associated with this video, because it will make sense when you see the next video that I'm about to play for the court as well. And I will caution the court that in terms of this racist video, it's a little disturbing.
Oh, you got some music on your phone sitting in the quiet ass car with your ass? Yeah, bro, that slaps.
I'm an Alabama nigger and I want to be free. Hell with the NAACP. I don't drink, I don't cuss. I want to ride on the front of the bus. I'm an Alabama nigger and I want to be free. Hell with the NAACP.
In context, Travis McMichael received a video, laughed at it, and turned around and resent it to a friend of his, involving the same song dubbed over another video. So you have the same song, different video, two defendants living in the same house. In this instance, Travis McMichael, having received it, laughed at it and sent it.
All right. Well, I think it's time for us to...
Understood. In sum, Judge, as I submit this to the court shall be authorized to release a person on bail if the court finds that the person poses no significant risk of flight, danger, risk of committing new felony, risk of intimidating witnesses, or obstructing justice. Your Honor, we've presented evidence in rebuttal as to each of these 4 factors, and any one of which would be sufficient for this court to deny bond and bail in this particular case. So my final thoughts, Your Honor, is that you should deny bond here. Defendants are not entitled to it. They've been indicted in a timely fashion. There are no time frames that are applied to them because of our judicial emergency and because of the timeliness of our indictment, nor are they deserving. I submit to the court that the evidence presented to the court shows that they are poor candidates for bond. They're not entitled to it. I will remind the court that we are aware of a pending speedy trial demand that's been filed by co-defendant Mr. Bryan. Fortunately, because of the judicial emergency, we don't need to be too worried about those time constraints now, and I understand the terms of court here in Glenn County are 6 months versus in Cobb where they happen to be 2-month terms. But my point in saying that is we're cognizant of the fact that we've been put on notice that speedy trial issues, once we're able to try the case, will be an issue, Your Honor. And I can stand here affirmatively for the court and tell the court that we'll be ready. As soon as it is feasible to try this case, we'll be ready to try the case. I would suggest to the court that the appropriate remedy today is to deny this bond. And if we're unable to get this case ready and tried when it's feasible for us to do that, the issue could always be revisited by the court at some later date. Thank you, Your Honor.
Thank you, Mr. Travis.
Your Honor, it's a bit like being in Wonderland, where the actual characteristics of a person don't matter, but the information, the evidence that's in dispute is what the state's asking the court to rely on to deny bond. The best predictor of future behavior, which is what this court has to do in this case, in determining whether to set bond, is past behavior. Travis McMichael twice has sworn an oath to uphold the laws, to abide by the laws, to follow orders as given. Once when he enlisted in the United States Coast Guard, and the second time as a commercial captain with Metz and Marine. Everything about his life has been consistent with upholding his oath, to abide by the laws, to follow orders when given, and to go above and beyond the call of duty. That's who Travis McMichael is. And the state glosses over and says, we don't need to worry about that. This is not the day for gold stars. This is the day for gold stars. This is when past behavior matters. Because it's up to this court to examine the person who you've never met, you know nothing about, until we provide you evidence. Evidence in the form of witnesses who know Travis McMichael. Evidence in the form of a criminal history printout. Evidence in the form of documentary evidence. I mean, that's what we've done over the last day, and I know it's been a marathon. But we brought to the court Travis McMichael's mother, subjected her to cross-examination, and what she told you is, Travis, born and bred in Brunswick, all of his ties are here in this community. He's got a now 4-year-old son, the court has pictures of, who means the world to him. Suggesting, Your Honor, fairly strongly that he's not a risk to flee, because if he did, he would never see his son again. You know, it's easy to get a preacher to come in and say good things about a parishioner. That's kind of their job. In this case, we have the mother who is no longer, the mother of Everett, who is no longer in a relationship with Travis, who shares custody 50-50, who engages with Lee McMichael on a weekly basis, who is still part of their lives despite the fact that they don't have a relationship anymore. They just share Everett. And I think that speaks volumes for Travis. Lee McMichael told you about Travis's financial situation. He's got very little money. I think she said he had $6,000 to his name. Where can he possibly go and survive with that amount of money? Not to mention the media that's present and covering this case. Where in the world could Travis McMichael go, flee the jurisdiction of the court without being seen, recognized, and delivered back, never to see the light of day again? It'd be ridiculous. Travis McMichael has abided by every order ever given to him by commanding officers. And that's why we took the time, and I know it may have been a little bit wearying, but we took the time to put in all of those things about his Coast Guard career. The state wants to say he's dangerous. He poses a danger to the community because he has private exchanges of an offensive nature, no doubt about it, with his friends in the community. But if you look at his behavior, his actual behavior towards other people, towards people of all races, all religions, all socioeconomic classes, you see a man who is known as the life of the party, funny, a mentor, someone you want there with you when things get dicey. You saw the letters of commendation, the lives he's saving, black and white, when people are in trouble. Kurt Hall, sergeant in the Marines, a person of color who lived with Travis McMichael during the time they were posted, I believe, in Pascagoula, who had nothing but wonderful things to say about Travis as a person, as a Coast Guard enlistee, and as a man. And so if past behavior predicts future behavior, that's who you're dealing with. Someone who abides by the rules, someone who is willing to abide by any conditions this court sets, someone who goes above and beyond to save people, no matter what private offensive messages he has with friends. That's a diversion. And you know it's a diversion, Your Honor, because you have Travis McMichael's criminal history. He's 34 years old. There was not one thing brought into evidence by the state to indicate that Travis McMichael commits felonies or poses a danger to anybody except the disputed facts of this case. He shows the video, the now infamous Roddy Bryan video, to prove that Travis is a danger to the community. But as my esteemed colleague, Mr. Hogue, has once said, that's the knothole in the fence. To look at that video and claim that Travis McMichael is a danger to the community fails to see not only the span of this case, which we will get into, but the span of Travis McMichael's life. And so when we talk about Ashley Langford, Ashley Sawyer, Lee McMichael, Zachary Langford, Sean Sawyer, Kurt Hall, we are talking about people who grew up with Travis, who have known him since grade school, in the case of Lee McMichael, obviously since he's born, but certainly from grade school, high school, Coast Guard, post-Coast Guard, Metzen Marine, living in Brunswick, this county. He's not a danger to flee. He's not a danger to the community. In fact, he is an asset to the community. And he's proven that by always being employed, paying his taxes, never getting in trouble, never confronting people unless he himself is put in danger. And that was one time by one man named Ahmaud Arbery. And actually, Mr. Arbery confronted him twice. Nobody else in the span of Travis McMichael's life has had a run-in with him. The Ayala factors, the bond factors, risk of flight is not risk of flight. It's significant risk of flight. It's significant danger to the community. It's significant risk of committing a new felony. It's a significant risk of intimidating witnesses. We put into evidence 3 affidavits: Matthew Albenzi, Ronnie Olson, and Diego Perez. All 3 of whom have had conversations with Travis McMichael, as Mr. Evans points out. They had conversations with him prior to February 23rd, and they had conversations with him after February 23rd. And not one of those conversations has been any kind of attempt to intimidate. In fact, as the affidavits say, they themselves swear there's been no attempt to intimidate them. But even better than that, Mr. Evans has a whole file, a stack of documents of interviews by the GBI. His evidence shows there's no attempt to intimidate by Travis McMichael. They've all been interviewed. Diego Perez has been interviewed probably twice. Matt Albenzi at least twice. By Glenn County, by GBI. None of them have said Travis McMichael tried to sway their testimony, intimidate them one way or another. It's ridiculous to play these jail calls or make insinuations that Travis McMichael is trying to obstruct justice. There's nothing about him in his background that is consistent with that argument. There's months and months of jail calls from Travis McMichael to his mother. There's no phone calls to Matt Albenzi, no phone calls to Diego Perez, no phone calls to Ronnie Olson or any other witness in this case with Travis saying you need to testify a certain way or don't testify. He's made a big deal about telling Lindsay to get off her phone and close her account. This poor girl, with whatever kind of judgment she lacks, takes a picture of the scene on February 23rd and posts it. It's not evidence. They have 1,000 pictures of that same scene, but it is incendiary, and there's no point to it. It just creates passion in the community. It infuriates people, as it should. It was a bad mistake by Lindsay. So rightfully, Travis wanted her to take it down. It doesn't help him to have that picture out there. It's not get rid of it. There's 1,000 pictures of the same site. It didn't hinder the investigation whatsoever. February 23rd is the date of the incident. He's not arrested until May 7th. There's not one piece of evidence presented to this court that in that time span, March, April, first week of May, Travis McMichael made plans to flee the jurisdiction of the court, talked to anybody about the possibility of fleeing the jurisdiction of the court, attempted to intimidate witnesses or obstruct justice, committed any new felonies, or posed any kind of danger in the community. He's never posed a danger before or after February 23rd. And I would submit to the court, he didn't pose a danger on the 23rd. The danger came from Mr. Arbery. The court has mentioned, of course, several times, and we've gone over this preliminary hearing transcript. The problem with relying on a preliminary hearing transcript is the goal for the defense in a preliminary hearing is not the same, as we've pointed out, as in a bond hearing. Agent Dial was not challenged in the accuracy of his testimony at the preliminary hearing. Quite the contrary, the questions posed to Agent Dial were open-ended questions, as the court recognized, designed to get discovery. It was not really a question of probable cause. And so when Agent Dial testifies that Ahmaud Arbery is a video game player, a jogger, an athlete, that doesn't go challenged. And so we don't want the court to think because it doesn't go challenged that it actually is the truth in the case. There are a number of instances in the transcript where Agent Dial is flat out wrong. And that is why we put some of these matters into evidence, not only to show that the preliminary hearing transcript is inaccurate as it relates to Agent Dial's testimony, but to show the court that this knothole the state wants the court to view the case through is incomplete. It's obviously too small a perspective. We need to knock down the fence and look at the whole case. And this is what the case is. And this goes to future dangerousness or risk of flight. You have, Your Honor, the Satilla Shores Facebook page. There's no question that the neighborhood was on edge, that there had been an uptick in property crimes dating back to 2018, certainly by 2019. Everybody's talking about it. Hey, there's been another break-in at the garage. There's been a theft of weapons out of cars, both in Satilla Shores and Royal Oaks, which is the next door neighborhood. I guess on the south side of Highway 17. Greg McMichael sees a man in July of 2019 that he thinks looks shady. He's living under the bridge. There's already property crimes. He's concerned that this man might be the guy who's causing a lot of these break-ins in the neighborhood. So what does he do? He calls the police, Glenn County Police Department. He doesn't pull a weapon on this man. In fact, the man is a white man who's homeless, who lives under the bridge. Officer Canego responds, and there's really no reason to suspect this man of anything. And nothing happens. Greg McMichael nor Travis caused any problems for this man. They just wanted the investigation to be done to make sure he's not responsible, because they are also on edge like everybody else. But the man was not black, and that's what's significant in this case. If the state wants to argue that Travis McMichael, because of his offensive private exchanges with friends, poses a risk to the community, there's no evidence to support it. What was concerning was that someone, white or black, was committing these crimes, or some group of people. October 25th, Larry English has a break-in his house. He calls the police. There's video of it. He says there's a man plundering my house. He looks like he's drunk or on drugs. He's kind of stumbling around. This we would submit as Ahmaud Arbery's first encounter with Larry English. It's at night. He has no reason to be there. Agent Dial testifies, well, maybe he's looking for water, or maybe he's interested in the electrical system of the house. It's at night. Larry English calls the police. He does not get caught, obviously. A month later, November 17th, there's actually a couple on the property. Larry English calls the police because of a white couple on the property who he suspects of stealing or intending to steal from him. He relates in that call, I believe, that items were stolen previously during the previous intrusion. $2,000 worth of equipment was stolen from a boat parked inside the house on the property. The only person we know was there previously is Ahmaud Arbery on October 25th, 2019. The very next day, November 18th, Ahmaud Arbery is back in the house where he shouldn't be at night when he shouldn't be. English calls the police. Again, they can't catch him. English relays to the police, hey, today on the 18th, I got my boat out of there. It had been ripped off. I lost cooler. I lost electrical equipment. I had to come get my boat out of there. So when Agent Dial testifies at the preliminary hearing that Larry English never told us anything was stolen, well, either they did a bad interview of Larry English or Larry English lied to him. Because he's on 911 call, and the court has it, describing the items that were stolen out of the house, out of the boat, during this time period. And he's sharing these videos with the neighbors, with Diego Perez, who's sharing them with others, and they're talking about it on the Facebook page. The very Facebook pages that you have in evidence. December 1st, Larry English calls the police again because he sees a guy, or sees the car that he thinks belongs to a guy under the bridge again. We're back to the under the bridge guy. And he wants the police to come investigate. He's talking to Officer Rash, both through official channels and on his cell phone during this whole time period. That turns out to be nothing. I don't think they ever found the guy. There's no real report of what happened after that. January 1st, New Year's Day 2020, 2 cars that I know of are broken into and weapons are stolen. Travis McMichael, when you have that police report, he calls the police. And a woman named Christy Barber in Royal Oaks, a neighboring neighborhood. She has multiple weapons stolen out of her car. All this, again, is plastered on Facebook and everybody's talking about it. And it's dangerous. Someone is stealing their guns. So now people have guns illegally. Critical date for the court is February 11th, 2020. Travis McMichael is driving to the gas station at night, 8 o'clock at night, to get gas for the next day when he drives to work. As he passes Larry English's house, he sees a man trying to hide, trying to act furtively, hide behind the porta-john that's out there, and he kind of backs up and puts his car lights on that person. He sees that person, who we think is Ahmaud Arbery, reach into his pocket as if he had a weapon. Travis immediately backs up, goes home, calls 911. Officer Rash and other officers come. Diego Perez comes over. Everybody's trying to catch the man we now know as Ahmaud Arbery on that property. But now he's armed, or suspected of being armed, and he's committing a burglary. He's at that house for the 3rd time now in 3 months, when he has no business being there. And that's why when they see him, when Gregory McMichael sees him hauling ass down Satilla Drive on February 23rd, he knows who that is. And I say hauling ass, that's in quotes. That's how Greg described it. And the only reason they had weapons, as they say in their reports, is because they believed he was armed, based on the prior incidents. That's the broader picture. So yes, when Travis McMichael posts, we need to arm up, we're under attack. We Satilla Shores people, we Royal Oaks people, we're being ripped off left and right. We need to protect ourselves. They now have guns, by the way. Our guns, whoever they are. We got to be careful. Does he do anything? Is there any evidence that during this time period, Travis McMichael took it upon himself to be a vigilante? The word Mr. Evans likes to throw around, Officer Rash would call it neighborhood watch. Yes, keep your eyes open. If you see somebody, call the police. That's what he does. That's what he does on February 11th. You have Travis McMichael's statement. He thought his dad had called 911 on February 23rd. Greg McMichael forgot his gun. By the time Travis realized 911 had not been called, he called it himself. And he gave his phone to his father, and you have Greg McMichael's 911 call. You have the body cam of Travis McMichael's interview with the police. At the scene, the man had just shot someone who attacked him. He cooperates immediately with the police. He says, literally, do whatever you have to do. Don't mind me. He's covered in blood. He tells the police within seconds of the incident, literally seconds, what happened, how this occurred. And he tells them exactly what I'm telling you. He goes to the police station an hour later. By the time they get him down, maybe it's 3 o'clock, 3:30. He provides a written statement and a map of exactly what happened. Not only on February 23rd, but going back to January 1st when he was a victim and his gun was stolen, February 11th when he saw this man that he recognized on the 23rd. Cooperates with the police in every which way. Talk about obstruction of justice. Travis McMichael is the poster child for cooperation with the police. He's read his Miranda rights. He could say, sorry, I'm not giving you a statement until I talk to my lawyer. He gives a full written statement, which you have. He talks to the police on the scene. He's law enforcement. He has had arrest powers. He understands the job they have to do. He wants them to do their job. He gives them the evidence to do their job. This man is not a risk of flight. He poses no danger to the community whatsoever. Certainly not a risk of committing felonies. And we know, with facts and not speculation, that he's never tried to intimidate witness or obstruct justice. If the court has fears that if I grant a bond, some of these things could happen, there are ways to prevent that. The court could order a bond secured by pillars of the community's property, people who are willing to put their lives at risk, certainly their economic lives at risk, by providing security in the form of their property. I think we totaled it up to about $400,000+ worth of equity. To secure his appearance, the court could order house arrest, either in this house here in Brunswick, or in another house in Brunswick. I think Zach Langford said he would take him in. Or, if the court felt there was a safety issue, we could put him in a relative in Florida. He could waive extradition. He could wear an ankle monitor. You would know where he is at all times. You could require him to surrender a passport, which I think we heard from Ms. McMichael, there's no passport. You could require that he not possess a firearm. Make sure no one else in the house in which he lived possessed a firearm. Any qualm the court has about the 4 factors can be remedied with conditions of bond, and should be remedied with conditions of bond. That's the appropriate way, with all due respect, to handle this situation. Travis McMichael is not a career criminal, nothing but abided by the law and rules his whole life. He will abide by this court's rules. He will abide by this court's conditions. We would ask this court to set a bond pending trial where these issues in dispute can be determined. Thank you.
Thank you. take 5 minutes. And then we'll, it's great. 5 minutes.